Hey everyone, welcome to Legally Speaking, here today with Matt and William, both personal injury attorneys with Matt Hardin Law. And hey, if you love the law and pop culture, well, they've got an exciting new project that you'll be interested in. Tell us more.
Well, we are starting a new podcast. It's going to be called The Pop Culture Courtroom. And what we're going to do is take famous scenes from movies, TV shows, and the like, and then analyze whether or not someone would have a court case based on what happened in the scene. So today we're going to give you a little sneak peek and talk about Caddyshack.
There's a memorable scene where the character Bishop Pickering insists on playing a round of golf despite an impending storm. As the weather gets worse and worse and the lightning begins to strike, the Bishop becomes increasingly determined to finish his round of golf, continuing to play. Eventually, after a good shot, he raises his golf club high in triumph, only to be injured as he's struck by lightning.
All right, guys, so does he have a personal injury claim from getting hurt on the golf course? What do you think?
Well, two major things stick out to me about this scene that could put the golf course at fault. First, the golf course didn't have any sort of horn or siren go off warning the golfers to get off the course. And second, the Bishop asked the caddy, an employee of the golf course, what he thinks. And Bill Murray's famous line, "I'd keep playing, I don't think the heavy stuff is going to come down for a while."
Well, there's also something that's called respondeat superior in Tennessee, which is usually is going to mean that a employer is going to be responsible for something that an employee does. Now, as to the Bishop, he definitely has some fault here. He's gone out in a lightning storm. He's got a metal stick. He's waving around for hole after hole as the storm gets worse and worse. He's definitely going to have some fault and some responsibility for this, what happened to him.
All right, I have to ask, so would you take the case?
For me, it would depend on the comparative fault standard in the state. In Tennessee, we have modified comparative fault, so you can't recover damages if you're 50% or more at fault. Given the obvious nature of the storm, I think that would be too big of a hurdle to confidently get over having to get 12 jurors to agree on. So in Tennessee, I'd say no. In Kentucky, where there is pure comparative fault, and you can recover something even if you're more than 50% at fault, I'd be more likely to take it.
We're going to agree on this one. I think it's a close case. I think it probably ends up with a jury doing 50-50 to each of them. You've got the employee telling them to play in the lightning storm and it's okay. And you've got the Bishop who's decided to play despite knowing what the weather is. And then you've got the last factor, which is everybody loves Bill Murray. Nobody's going to put this on him.
There you have it, guys. Thanks so much for joining us. And you can find their new podcast, Pop Culture Courtroom, wherever you listen to podcasts.